Hello, and welcome back to Chapter 2, The Legal Environment of Forensic Accounting. We are covering Learning Objective 4, Describe the court's gatekeeping role in determining the admissibility of evidence. The trial judge runs the courtroom and makes all legal rulings, including those regarding the admissibility of evidence. In general, the rules of evidence put a premium on first-hand observations. Opinion testimony is discouraged, except under certain circumstances, such as expert testimony. And hearsay evidence is generally excluded. The court's role as a gatekeeper for evidence is paramount, especially in the world of forensic accounting. The rules of evidence allow expert witnesses greater latitude than other witnesses to testify based on evidence, such as hearsay, that would not otherwise be admissible. A higher level of credibility is generally attached to an expert's testimony. So the trial judge is challenged to carefully qualify both the expert and his or her testimony. Rules of evidence. The rules of evidence may vary from jurisdiction to jurisdiction and even from court to court, such as criminal, civil, or family court. However, most state rules of evidence are based on the Federal Rules of Evidence, FRE. The purpose of the Federal Rules of Evidence is stated in Rule 102. Rule 102 reads that these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law, to the end of ascertaining the truth and securing a just determination. So the purpose of the Federal Rules of Evidence is to seek justice and truth in a fair and reasonable manner. Evidence is something including testimony, documents, and tangible objects that tend to prove or disprove the existence of an alleged fact. Evidence is presented to persuade the fact finder, the judge, or the jury of the probability of truth of some fact asserted in that case. And according to the Federal Rules of Evidence 401, relevant evidence must have the tendency to make a fact more or less probable than it would be without the evidence, and the fact must be of consequence in determining the action.